Hello, good morning, good afternoon. Thank you for tuning in to another Thursday Live with Chugh. Each week, we cover pressing topics that matter to you and your business. My name is Min Kim. I'm a partner and immigration attorney here at our law firm's Edison, New Jersey office. As you may already know, Chugh LLP is a full service legal, accounting, and immigration firm that serves businesses across the United States, India, and around the world. What we will be covering today is adjustment of status applicants and the travel concerns that green card applicants should bear in mind. Feel free to enter any questions that you might have into the chat box at any time during the presentation, and I'll proceed in answering your questions live. And a quick disclaimer before we get started, this event does not create any attorney-client relationship and does not constitute legal advice. It is only intended to provide general information to the audience, and all information in this webinar should be independently verified before acted upon. So with that said, let's get started. Once again, with the immigrant visa numbers moving forward as they are for traditionally, historically backlogged countries such as China, India, etc., a lot of eligible foreign nationals waiting for many years. They're considered current now, and they're looking to apply for their adjustment of status application to finally secure U.S. permanent resident status here in the United States and make the U.S. their permanent home. But obviously, the adjustment of status application it does present itself as maybe the one final step needed in that process, but it's a lengthy process. And with that noted, there are concerns when it comes to travel needs and the impact of international travel on your pending green card case. And that's what we're looking to talk about here today. So just to kind of start off, the green card process is a lengthy process. Most people go through it through a sponsorship of a labor certification through their sponsoring employer, and then subsequently an I-140 immigrant petition filed with USCIS. So the first question right off the bat, are there any travel restrictions pertaining to those steps? And the answer to that is no. When you're going through a perm labor certification process sponsored by your employer, as well as once the perm is approved and certified at the Labor Department agency, you're sponsored for an I-140 petition, and that's filed and pending and in the queue with USCIS. You are permitted to travel internationally, provided that you have a valid, unexpired visa stamp in your passport. The travel concerns, I suppose, they start at the adjustment of status stage, as I referenced earlier. Once your priority date is current and you're eligible to adjust status to the U.S. and you prepare your Form I-485 application for adjustment of status, some things to bear in mind are those significant milestones. When the application reaches USCIS, when you receive your receipt notice from USCIS acknowledging that the agency has received your application for adjustment of status. Thereafter, a biometrics appointment is scheduled. And then subsequent to that, if you file your advance parole travel document, the travel document that advance parole eventually being approved. So those are the four milestones to kind of bear in mind just moving forward. And those are the four milestones to bear in mind just moving forward. And there are travel issues pertaining to each one of those items. So what I typically advise my clients is that is if there is a way to remain in the United States through that entire process, from when USCIS first receives your application for adjustment of status all the way to you receiving your approved advance parole from USCIS, that Form I-131 advance parole document, that's always the best course of action. So I mean, luckily, I suppose you and whoever you're working with, whether it be someone from within your company's HR department, or perhaps you attain the services of an attorney, of a legal provider who is kind of familiar with these rules. Work with that person and kind of understanding that if you have to push the filing of the adjustment of status, perhaps by a couple of weeks, a couple of months, then that's always the best strategy here, so that you can be assured that you'll be in the United States for the many months that it will take until the advance parole is eventually approved. If that is not an option, and there is some kind of intervening immediate need to travel overseas, at the bare minimum, you must be physically here in the United States when the adjustment of status application is first filed with USCIS. So when your attorney, when your employer, or perhaps you're just filing that application directly with USCIS, from a personal standpoint, when you mail the application to USCIS, you physically have to be in the United States. And I would advise to continue to be in the United States until that receipt notice is received. The receipt notice is the formal acknowledgement that USCIS has safely received your application. Until that is received on the part of the applicant, then I suppose we're kind of presuming that the application has reached safely to USCIS. You can receive a USPS confirmation. You can receive a FedEx confirmation saying that the package has arrived safely at the mailroom at USCIS. But I suppose until the official receipt notice is returned to you, it's not official. And I suppose there always is a sliver of doubt there. So if there's a way to wait in the United States before you look to travel overseas until the receipt notice is returned to you, that's also best practice. Um, After that, as I mentioned, the next milestone is the scheduling of the biometrics appointment. And here, once again, depending upon the availability at the USCIS Application Support Center, biometrics are typically scheduled, I want to say, 4 to 8 weeks after you file the adjustment of status application with USCIS. And it is advised to remain in the United States until the scheduling notice arrives in the mail and you attend your appointment and you submit your biometrics to immigration. And the reason behind this is, although it is possible to reschedule your biometrics and make a request for a later date, given any kind of intervening travel plans that you have, it's rather challenging to get the rescheduling request process. So instead of going through that entire headache of wondering if USCIS has received the request, whether the appointment has been rescheduled, because things are still kind of processed through snail mail at USCIS, in order to avoid any kind of issues later on. If there's a way for you to remain in the United States until you submit your biometrics, that would also be recommended. And then finally, the last milestone is obviously the approval and the issuance of the advance parole. So the advance parole, just as a general background, it's an ancillary benefit document that you as an adjustment of status applicant can submit. It doesn't mean that you have to submit, but you can submit to USCIS. And upon the approval of that, basically USCIS is saying that you have travel privileges, to and from the United States until a decision is reached on your green card application. Now, the issue with the advance parole is that it is a benefit document, and it's at no additional cost. There's no filing fee attached to it. So, if anything, applicants have every incentive to include that along with their adjustment of status filing. But it requires the adjustment of status applicant to remain in the United States the entire time that it remains in process and pending at USCIS. So, I suppose we go back to traditional USCIS processing times, how long does the agency take to approve these applications? Well, unfortunately, they take quite a lengthy period of time. On average, it's about 4 to 6 months, I would say, and it's a lot asking someone where perhaps maybe they have some family overseas, perhaps they have travel obligations pertaining to their work here in the United States that they have to visit other countries for for employment purposes. It's asking a lot for that person to remain landlocked here in the United States for perhaps as much as 6 months. But if there's a way to kind of plan the filing that you can also include the advance parole and file everything together and be confident that you could be in the United States until that advance parole is approved, that would be the best course of action. If that cannot be done and if travel cannot be avoided, as I said, the advance parole does not have to be included as part of the original adjustment of status application that you intend to file with USCIS. You can file it subsequently as well. So you file the primary I-45 application for adjustment of status, and then at a later point, can you file the advance parole? Absolutely, you can do that. So know your travel schedule, communicate that clearly to whoever you might be working with in processing these cases with USCIS, and then I suppose those travel concerns should not become an issue. A quick add on though to the advance parole. Um, so the advance parole is especially important for individuals in a visa category other than an H or an L. So let's say that you're here, based upon an E2 visa category, or you're here, because you're an O1 extraordinary ability researcher, and that you're here based upon an approved O1 visa petition in your name. If that's the case, you must have the advance parole in order to travel overseas and then return, because otherwise you risk abandonment of your filed and pending adjustment of status application. So that's an important difference. If you're an H-1B or an L-1, because those two visa categories, because I mean, I suppose they're fairly common, and a lot of individuals hold those specific visa status. USCIS has carved out an exception where you do have the option to perhaps travel overseas without the advance parole yet approved. But if you're in a visa category other than an H, other than an L, then yes, you would have to wait until the advance parole is approved in order to seek return entry back into the US as a parolee. So that takes us to the next topic that I wanted to get to, and we understand that obviously there's a lot of life circumstances kind of going around, especially nowadays with the pandemic, and there might be an urgent, pressing need to travel based upon humanitarian reasons, and that brings us to the next topic to talk over, which is the request for an emergency advance parole. So this option does exist. It is limited. And I suppose if there is an underlying humanitarian reason, primarily, let's say a death in the family, someone is gravely ill, overseas, and you have to visit that person, the advance parole is not yet approved. What can be done about it? Well, the rules as they currently exist, it allows you to make an application in person to a USCIS field office for something called an emergency advance parole. And the emergency advance parole, basically, it's for the situation where there is a life there is a life situation, a life event that kind of gets in the way, where you cannot wait any longer, and it's against humanitarian reasons to force you to wait in the United States and bar you from traveling overseas. Now, there's a specific procedure involved. If this happens to pertain to you, there is a specific procedure involved in requesting this emergency advance parole from USCIS. The first thing that you must do is to contact the USCIS Customer Service Center, that 800 number that's commonly found in the USCIS notices, issued to foreign nationals. You would have to call that number and explain your situation and request for an emergency advance parole appointment. And the USCIS contact center will probably then schedule a callback to you. So a tier 2 USCIS officer will call you back within around 3 business days. So when they call you back, after those 3 business days, that tier 2 officer has the discretion then to schedule an emergency advance parole appointment for you at your local USCIS field office. Um, but I suppose before that happens, so you would have to be rather convincing and inform the officer that your situation, whether it be a death in the family or family medical emergency, etc., it justifies the need for this very discretionary benefit to be issued to you. But let's say they do end up scheduling that appointment for an emergency advance parole to you on the date where you have to appear at the USCIS field office. Some of the things that you should bring with you is a completed advance parole form. The form number is the same as the regular advance parole. It's Form I-131. It can be found on the USCIS website. You would have to bring the appropriate filing fee that you submit directly to the field officer once you visit, as well as documentary evidence that the emergency does exist, whether it be a doctor's note, whether it be some kind of certificate that you receive, that you can perhaps attain, kind of documenting that there has been a death in the family that justifies the reason that the emergency advance parole should be carved out, and that this document should ultimately be approved for you. And then finally, 2 passport-size photos, because that's a necessary component in getting the advance parole issued. Once you have these things on you and you make your appointment and you speak with the field officer there, and they're convinced, they can issue the emergency advance parole document, so that you won't no longer have to wait for the service center to approve the advance parole, but that you can immediately hop on a plane and then depart to attend to your emergency. So we talked about the advance parole. We talked about the travel issues to bear in mind as you kind of navigate through the green card process. With the short amount of time that we have left, I do want to talk about one final issue, and this just kind of going back to my original point of the disclaimer that I opened with. If you happen to find yourself in this particular circumstance, I would definitely advise to speak with a legal professional, an attorney, who specializes in immigration, so that you'll be able to be better informed in making a judgment call on your next options if you find yourself within this specific pattern of events. But what I'm speaking to is basically the potential to abandon your I-45 application for adjustment of status if you happened to depart the US without the advance parole first being approved. Now, I know what I mentioned before. If you're an H-1B or an L-1, that really is not a concern. And that's true. And the reason for that is because there was a USCIS memo that was issued about 20 years ago that specifically carved out exception for dual intent visa categories, namely the H and the L. Once again, if you find yourself in a different visa category, an E, TN, O for instance, P, it's critical that you wait for your advance parole to be approved first before you have plans of traveling internationally. But let's say that you're an H-1B employee, or perhaps you're a derivative spouse, an H-4 spouse, or an L-1 or an L-2 spouse. Are you at risk of potentially abandoning your adjustment of status application if you happen to leave the US without the advance parole being approved? Well, the answer to that is it depends. And I suppose it depends because it's very fact specific, and it's very unique to the type of guidance that you rely on. Just as a backdrop, as an immigration attorney, what immigration attorneys, I suppose the Bible that we reference is the immigration rules. I mean, that's the law that governs the land in terms of immigration issues. So there is an immigration rule that does state that if you are an H-1B or an L-1 and you are in that status. So you have a approved unexpired H-1B extended for you. You're an adjustment of status applicant. You have an approved unexpired L-1, approved for you while you're going through the green card, and you depart the U.S. and you return um, using your advance parole. You're okay. You're safe. The issue is if you allow your H-1B validity to expire, to lapse without extending it, and you allow your L1 to lapse without extending, and the same thing goes for derivative spouses, the H4 and the L2. What happens there? Here, there is a conflict in the in the rules. The regulations, as they say, the quote unquote Bible that practitioners such as myself rely on, there is regulatory authority that speaks to this, that kind of implies that you're in danger of abandoning your adjustment of status application because you did not maintain your H-1B or your L-1 prior to your departure. Now, if you did maintain your non-immigrant visa status, the underlying H or underlying L, you're safe. But if you did not, then I suppose that might be a potential red flag. Does that mean that it's automatic that it will be abandoned? No, because as I said, there's a conflicting guidance out there. So there is a travel memo that was issued about 2 decades ago, and that is what practitioners such as myself rely on in arguing that there is no abandonment here. And for the most part, that has held true. And we've seen historically that USCIS has agreed with us. But I suppose I'm bringing this point up because, for the general audience, if you find yourself in this situation, it is always best practice to play it safe, to maintain your H-1B and your L-1. Now, I understand that it's not just a decision that you, the foreign national going through the green card process, makes. Obviously, there's a sponsorship component to that, and it has to be agreed to and funded by your sponsoring employer. But if all parties are on board, there really is no drawback to maintaining your continued visa status while you're going through the green card process. Now, people ask me, well, I mean, it's not necessary, is it? I have an approved EAD, the EAD Advanced Parole Combo Card, because I filed that with USCIS. Can I not have work authority based upon the approved EAD? And the answer to that is yes. Of course you do. And you have unrestricted travel privileges because the advanced parole has also been approved. But in order to rely on that continually, given the delays at USCIS in extending these applications, the EAD and the advanced parole, it's risky. So just as a general sense, if you want to make sure that the years of waiting that you did, before your priority date became current, and now you're able to file that adjustment of status application after those years of wait, if all that's going to be paid off in the end, I would definitely advise to make sure that you do your darndest to extend your visa status while you're going through the green card process. There really is no drawback, and the payoff can be huge because then those unnecessary risks of potential abandonment that the immigration regulations speak to, that all of that can be avoided. So I know that we're coming close to the end of our time, and I do see one question here in the chat box. So the question is from an audience member. I have an advanced parole approved. I recently filed to renew my advanced parole, but the advanced parole renewal is pending. I need to leave the United States. Will I abandon the advance parole renewal if I exit? So this is a good question. The answer to this is it depends. um, if your original advance parole remains still valid and unexpired, then you don't risk abandoning um, your advance parole renewal application. Um, and actually, the source of this question and the underlying reasoning is that the advance parole requires the applicant to be in the United States the entire time that it's pending. Kind of circling back to what I mentioned before. If you leave the United States before the advance parole is approved, then USCIS would deem that advance parole application as pending to be abandoned. It won't affect your green card application. It won't impact the continued adjudication of the adjustment of status application. But the advance parole itself, you will receive, a notice from USCIS saying that they cannot approve it, given your international departure that intervened. But the nuance to this question from the audience is a little different. They're looking to file a advance parole renewal. They have an advance parole approved, and if that approved advance parole is still unexpired and it's valid, by the time that they are looking to re-enter the United States, um, they can rely on that, and it will not affect their renewal advance parole application that's still in process. So I suppose that's a little a wrinkle to the to the general state of facts that the applicant should bear in mind. Okay, so with that, I suppose we can come to a close to our talk today. Once again, thank you so much for watching. If anyone in the audience, if you might have any further questions, please send them to info@chugh.com. Once again, info at chugh.com. And I would definitely recommend to tune in to our weekly live sessions every Thursday at 2 p.m. Eastern, 11 Pacific, for insights that can help you and your business thrive. Be sure to follow us on LinkedIn, Facebook, and YouTube so that you get notifications when these live events begin every week. And finally, I would ask that if you want to know more information about our law firm, our practice areas, whether it be immigration, accounting, or corporate law and litigation, please visit our website at www.chugh.com. Thank you.